Hi, everyone. I want to welcome you all to what I hope is an interesting and informative 60-minute experience. I'm Courtney Scheidel, and I am here with a number of my colleagues to talk to you today about how you can use contracts to avoid some nasty litigation in some very difficult jurisdictions. I'm a partner in the Charlotte, North Carolina office. I represent a number of clients, including product manufacturers as well as commercial entities in both individual and class action litigation. My experience includes internal investigation of and coordination of a client's response to federal regulatory as well as DOJ inquiries, related bankruptcy proceedings, individual tort actions, multi-district litigation, and ensuing state attorney general litigation. I am joined today by Rich Beaulieu. He's a partner in the firm's Atlanta office. Over his 12 years with the firm, Rich has represented clients in both environmental and product liability matters across the country. He also provides counsel to clients engaged in procedurally complex litigation, particularly in federal court and when facing punitive damages litigation. I'm also joined by Maggie Bowman. She is a litigator in our Richmond, Virginia office who focuses her practice on products liability, consumer, toxic tort litigation, as well as focusing primarily on medical device and chemical sectors. Her experience with complex litigation, including mass actions, class actions, and MDLs, has led her to defend clients in state and federal courts around the country. Finally, last but not least, Travis Gunn is an associate also in our Richmond, Virginia office who represents clients in a variety of matters, litigating issues including class actions, consumer deception, to tort law. He focuses on appellate and complex trial court litigation, as well as advising clients on proactive strategies to manage their litigation risk. We're here to talk about managing consumer litigation risk with contracts, the why, the what, and the how. First, the why. As we all know, jury verdicts are going through the roof. We have here before you the top combined value of the 100 top verdicts of 2019. Those are some very large numbers, and we don't expect them to start going down anytime soon. Especially with the COVID pandemic, as you know, there's a backlog of litigation, and we think that the courtrooms are going to start getting very active in the next couple of months. Here we have top 5 trial verdicts from 2019. As you can see on the left-hand side, there are some pretty big numbers out there. But what I want to focus on very briefly is the information on the right-hand side. You see the different courts where these huge verdicts are coming out of in a variety of different settings. You've got Pennsylvania and California, probably not that surprising to most of you. But then you've got North Dakota and Oregon. So what that tells you is you could be subject to a very, very high verdict in a number of different jurisdictions, not just the ones that we generally think of. We have here on the left the new 2020 to 2021 judicial hellholes as nominated by the American Tort Reform Group. I know a lot of you are probably familiar with this list, but it's worth looking at again. We have, as expected, based on the last slide we looked at, Philadelphia, Pennsylvania, and California near the top, New York City, and South Carolina, my home state, in the asbestos litigation. I can personally attest to the validity of that designation, followed by Louisiana, Georgia, St. Louis, Cook County, as well as Minnesota. Who would have thought? But judicial hellholes aren't just the ones on this list, and that's what we're going to talk about. What really matters and what really determines whether the jurisdiction you're in is dangerous for you or good for you is what kind of case do you have and what are the goals for the end game of your litigation. What do you want to do and how do you want to get there? There are a lot of things that you need to be thinking about. Is this a case that you want to resolve quickly? Or is this a case that you need to litigate? We all know that when you go into settlement talks, there has to be a real threat of going into the courtroom, that you will take a case to trial. And so that's something that you need to think about. Is this the right candidate to take all the way to a jury verdict and maybe even to the appellate court? Are you involved in multi-front litigation? Is this a one-off case, or is this part of a pattern litigation? Is there a regulatory investigation, maybe even a DOJ investigation, or the state attorney general's looking at this issue? These are all things that you need to consider. We all want to minimize financial exposure, but it might be worth paying a little more to limit discovery, resolve it quickly, to avoid some bad publicity for your company. And finally, a lot of times we need to go to litigation to establish some legal precedent. It may be that there's some unsettled law in your jurisdiction, or you've got a plaintiff's expert on the other side that you really think you've got a shot at because of the judge you're with and the courtroom you're in, of getting them kicked out so that you can use that order in later litigation. So in determining how you're going to manage your litigation and whether or not your jurisdiction is positive or negative for you, think about the kind of case and what your goals are. You need to think about the overall treatment in that jurisdiction of tort and contract litigation. It is still surprising to me how different tort law is from state to state, and you need to consider that. What types of defenses are available to you or not in your specific litigation? How are class actions treated? How are consolidated lawsuits treated? Again, that's something that you're really going to be more focused perhaps on what kind of judge you draw as opposed to the jury that you might be facing later. But you need to think about your judge, of course, because judges are the ones that are going to decide the key issues up front. Are you going to get proportional discovery? Are they willing to make some hard decisions when it comes to a Daubert motion, a dispositive motion, or a class certification motion? Again, you can be in a bad jurisdiction but have a good judge, and so you want to stay there as opposed to trying to transfer out of it. But, of course, you do have to look at the community where you are. What kind of jury are you going to have, and what kind of damages are you potentially exposed to? And finally, you might not be in a good trial room, but you've got a good appellate court. Are you willing to gut it out to get a verdict, but then take it up on appeal? Like I said, there are lots of different kinds of judicial hellholes. There's the bad judge, but a good jury. A good judge, but a bad jury. You need to evaluate where you are, what courtroom you're in, and it all depends on what your case is, what type of case, and what your goals are as far as resolving the litigation. And finally, how do you manage your litigation? You build a team. You assess your needs, and you build the right team. Depending on where you are, you might not want to go with the team that you typically use. Sometimes it's good to have the experience to put the band back together again, all the experts and trial counsel that you're typically used to using and know how to work together. But sometimes think about your audience. Think about the judge you're in front of and the jury that you're in front of. You need a diverse team, not just in the traditional sense of diversity, which is always important no matter where you are, but a diversity of thought, a diversity of experience, and a diversity of skills. Consider that when you're putting together your team of experts, corporate witnesses, and trial counsel. I'll turn it over to Rich now, who's going to talk about personal jurisdiction.
Thank you, Courtney. Courtney's done a great job describing the problem that you all are facing, which are jurisdictions that are going to be unfriendly to you and your interests in handling litigation. For the last few years, one of the top ways that defendants have tried to get out of those jurisdictions is the defense of lack of personal jurisdiction. Like so much in the law, however, we see now that that defense is in a state of flux. Something that seems constant is that in the legal system, whenever there's a major doctrinal procedural change that favors defendants, we see that advance, and then we see retrenchment. We saw this with Daubert. We saw it with Iqbal Twombly. We've seen it with summary judgment standards, Erie rules, and a variety of state tort reform efforts. Advances are made to help defendants, and then they're walked back. And where we are now in personal jurisdiction is in that walking back phase. Now, that doesn't mean that the defense is gone. It's still very much alive. And in a presentation focused on that, we could discuss ways to keep that defense active even now. But let's take a couple minutes and talk about how we can see that the future of the defense of lack of personal jurisdiction is uncertain. The case that we all learned in law school, unless you just got out, is International Shoe versus Washington. What happened in this case? Washington enacted a tax to fund its unemployment insurance fund. International Shoe is a Delaware corporation with its principal place of business in Missouri. It had some sales operations in Washington, very typical sort of arrangement for a multi-jurisdictional product selling company. No design work, no manufacturing work, no offices in the state of Washington, but it did have salespeople who sold shoes. So the question for the court, the Supreme Court, was, does Washington have personal jurisdiction over International Shoe such that it can maintain an enforcement action against the company to require it to pay this tax? And the court said yes. What the court was grappling here is the difficulty in applying a legal theory that is personal jurisdiction, which was designed to be applied to natural persons, individuals. You see that in the name of the doctrine, right? Personal jurisdiction. And it's really, generally speaking, pretty easy to tell whether an individual is in a state or not in a state. This is much more complicated with a multi-jurisdictional corporation that has its headquarters in one place, a manufacturing plant in another, and sells its product in a third state. So what the court said here was the test that we have all become familiar with, although going back and rereading International Shoe, it may surprise you that we got to the modern standard out of this case. But what the court is really concerned with here are, does the corporation have contacts with the state, and is it fair to haul the corporation into litigation in that state? And the core insight is this that's on the screen in front of you. Doing business in a state is a privilege, and that privilege comes with obligations, and one of those obligations is defending against lawsuits in that state. That is the core of what federal courts and state courts that are doing this honestly look at as the scope of personal jurisdiction. That understanding of International Shoe continued for about 70 years. During that time, the personal jurisdiction defense was available and was frequently raised, but was very infrequently successful because there was almost an anything goes sort of attitude as far as contacts with the state. And then in terms of fairness, most judges seem to regard any corporation as being amenable to being sued in pretty much any state. A watershed moment in the doctrine came, however, in 2017, where a group of plaintiffs finally overreached and caused a reaction from the Supreme Court to that overreach. And essentially what happened in Bristol-Myers Squibb is that a group of plaintiffs who were not residents of California and who had not been injured in California, really had no connection to the state at all, sued a pharmaceutical company in California based on injuries caused by the pharmaceutical company's products. And the question was raised again, does California have personal jurisdiction over that pharmaceutical company? And the answer there was no. And why was it no? The court gave two reasons. One is that whatever connections or contacts Bristol-Myers Squibb had with California, they were not causally related to the plaintiff's claims. And second, the plaintiffs themselves had no contacts with California, which meant that it was fundamentally unfair to drag Bristol-Myers Squibb into court there to handle these plaintiffs' claims, when neither Bristol-Myers Squibb's contacts nor the plaintiffs themselves had any contact with the forum. So this case came down, and what lower courts mostly heard was the first part, the requirement of a causal connection between the corporation's contacts with the state and the exercise of personal jurisdiction in any particular matter over that corporation. In other words, it didn't really matter so much how many contacts a given defendant had with the state if whatever those contacts were didn't give rise to the plaintiff's claim. And over the 3.5 years or so after BMS, we saw a lot of retrenchment in the lower courts. Judges, or at least a lot of judges, felt that this standard was too tight, that it was unfair, and they would try to skate around having to apply it. Not in every case, and certainly there were some great successes in applying the defense in those 3 years. But there was also an evolving jurisprudence of lower courts trying to limit what Bristol-Myers Squibb said on its face. And that issue came to a head just a few months ago in the Ford cases that were heard in the Supreme Court this term, and the decision just came down. Those cases involved Montana and Minnesota residents who were injured in car crashes and alleged that their Fords were defective, bringing suit against Ford in their home states. So we see immediately the one distinguishing factor from Bristol-Myers Squibb, which is that the plaintiffs in these cases had a connection with the forum that they sued in. And the Supreme Court caught on to that immediately and said that that was important in determining that the plaintiffs bringing claims in those states was not unfair. And that is the profile of litigation that we most commonly see. Most plaintiffs bring their cases in their own states. The Supreme Court also addressed the first half of the Bristol-Myers Squibb analysis, that is the causal connection between the plaintiff's claims and the defendant's contacts. Ford is a large motor company, has all manner of contacts in any state, sells vehicles, repairs vehicles, so on and so forth. But what Ford said correctly is that they had not designed or manufactured or even sold those particular vehicles that were involved in the accidents in those states. And the court said, well, when we said you needed a causal connection in Bristol-Myers Squibb, that's not quite actually what we meant. It's not really required that there is a factual but-for link. And so this is the first step in what is likely to be a significant retrenchment in the issue of the defense of lack of personal jurisdiction across the court system. So while that defense is still available and Bristol-Myers Squibb is still good law, and there are lots of ways to distinguish it from the Ford cases, there is indisputably a feeling amongst the judiciary and amongst litigants that the defense is going to be much less wide-ranging going forward. So one of your primary tools for getting out of those jurisdictions that you don't like is headed in the wrong direction. It's not gone, but it's walking backwards. Now, something else that defendants like to point to in terms of getting out of unfriendly jurisdictions are the terms of their contracts with their consumers. And Maggie Bowman is going to talk a little bit about how that may not be a perfect option for getting out of these judicial hellholes either.
Thanks, Rich. Right. So as Courtney and Rich have given you the bad news, I'm going to pile on a little bit, and then we're going to hopefully introduce some creative solutions for you to think about as you're crafting your contracts with your customers. So as Rich discussed, we think about contracts a lot in terms of what claims are we going to face under this contract. And we talk about breach of contract all the time, but how can we use contracts with our customers to help shape future litigation that's not just a breach of contract claim? How can we shape litigation to cover things like tort claims, personal injury types of claims that might arise against us, statutory claims like a Fair Labor Standards Act claim? And so we want to go over just briefly the most common litigation terms that are sort of the first avenue of defense. And everyone, I think, is going to be familiar with these, but I'm just going to give you a brief overview of the most common types of clauses. And then I want to talk a little bit about how even those are not really a panacea. They're not perfect, and there are some considerations, especially recently, that have come up that companies are going to want to consider when they are crafting their contracts. So first is one of our favorites, the forum selection clause. A forum selection clause obviously is going to allow the contracting parties to dictate which forum a plaintiff can sue a defendant related to that contract or related to a particular matter. And we like those types of clauses because the courts like those clauses. They're prima facie valid. And this is a really good tool to help avoid those judicial hellholes that Courtney was talking about that are so scary. Typically, a forum is going to be a particular state, but it can also specify whether a plaintiff brings suit in a federal court or a state court in a certain forum, depending on personal and subject matter jurisdiction, of course. The beauty of the right to contract is that the burden then becomes the plaintiffs to show that clause is not valid. The defenses are they vary significantly by state, but in general you're going to see defenses like the forum selection clause is unreasonable. It goes against public policy. I was forced into this contract by fraud, etc. But like Courtney talked about, we see this benefit to help craft where our claim is going to be filed against us. So, for instance, if I'm a Pennsylvania company and I'm based out of the Lehigh Valley, I better have a forum selection clause that dictates that any claim against me is going to be filed in Lehigh Valley, not in the Philadelphia Court of Common Pleas, because there probably would be personal jurisdiction against me in that court, but I don't want to be in that court if I'm a company. Next, we look at a corollary to that, which is the choice of law clause. So instead of identifying which court is presiding over my case, it's what state's laws and what substantive law is going to apply to plaintiffs' claims. This has a choice of law clause is going to have some requirements in order to be effective against a claim. So the chosen state law has to have a substantial relationship to either the parties or the transaction. I can't just pick Texas law just because I like Texas and how defendant-friendly it is. There has to be a reasonable basis for that application. And, of course, then the chosen state law can't violate the forum state's public policy. The benefits, again, because these clauses are specifying what state's laws apply to a lawsuit, to the substance of a lawsuit, they're going to allow, obviously, for the contracting parties to identify states that are going to have more favorable laws. If a company is based in Virginia and they can use they're a product manufacturer and they can use a choice of law clause in a contract, they might be able to use something like contributory negligence, whereas that might not be available in the state that they're sued in, and it probably isn't, frankly. The other benefit to a choice of law clause is for your defense attorneys, right? So if you've got cases that you're facing in many different jurisdictions, but you've got a choice of law clause that mandates that the law of Virginia applies, then that helps make your defense of all of these different lawsuits a lot more efficient. Then our third and probably our favorite that I think defendants have really latched on to in the last few decades is arbitration. An arbitration clause, of course, directs that a dispute must be arbitrated as opposed to filed in a civil court. And in particular, the Federal Arbitration Act is really favorable to arbitration. And there's a common law presumption that an arbitration clause is valid, assuming that the parties have agreed to it in the contract. And there's an arbitration award. It's incredibly difficult to set that aside, and so a court is only going to refuse to enforce an arbitration clause if the clause is both procedurally and substantively unconscionable. And you can imagine what a difficult burden that is for a plaintiff to show, and they usually can't meet that burden. The benefits are pretty wide-ranging, and defendants, especially companies, have found a lot of advantages in arbitration. I think one of the biggest benefits is countering what Courtney described earlier with these billion-dollar verdicts, multi-billion-dollar verdicts. You're a lot less likely to have a runaway jury type of award in an arbitration award. Your case is going to be arbitrated by ostensibly a neutral person, an arbitrator who's a professional in this area, and you're not as likely to see those outrageous awards. Another huge benefit is that settlements typically are confidential. You know, in a lot of states, depending on the type of claims, you may have to have a court affirm your settlement and do so in a public way, because courts are increasingly less likely to seal settlements. And so, for instance, if there are minors involved, you're going to have a public settlement, and a lot of defendants don't want that settlement to have to be approved by the court, as opposed to arbitration where you've reached your arbitration award, you've settled, and that's the end of the deal. But we see that these clauses aren't perfect. Number one is that all three of these clauses are still going to rely on a court to order what relief you want. So maybe you want to transfer a venue, maybe you want to dismiss for a plaintiff having filed in an improper forum, maybe you want to compel arbitration. But if plaintiff has picked their favorite court to file in, you're still relying on that judge in that plaintiff-friendly court to order what you want. Number two, the need for precision, and we'll see this a little bit later. Courts are increasingly requiring just mind-blowingly precise language to enforce clauses like a forum selection clause or an arbitration clause. And number three, cost. As these clauses become more complicated and as defendant companies update their language, plaintiffs get more and more creative. And we're seeing even arbitration, which typically has been seen as a more cost-effective method to litigate a case, we're seeing those costs increase and increase. Finally, finality. There is generally no right to appeal an arbitration opinion. And so when an arbitrator issues an award, you're pretty likely to be stuck with that. The Seventh Circuit says even clear or gross errors by an arbitrator doesn't authorize a court to set aside that award. And so the likelihood that a company, and of course also a plaintiff, but the likelihood that you are going to be able to change the award, whatever you get, you're most likely going to be stuck with that. The factors to set aside an arbitral award under the FAA are set out in the FAA, and they're pretty high. Corruption, fraud. I mean, those are things that are going to be really difficult to prove. I want to take a look at just a couple examples of where we see these clauses being pretty difficult sometimes. So this is an example out of Texas State Court, James W. Turner Construction Limited, and this is a recent case. So this involves a subcontractor pay dispute. Turner is a general contractor defendant in a case filed by its subcontractor after a pay dispute following construction in Puerto Rico after work was done after Hurricane Maria in 2017. So the The contractor, the subcontractor, and the general contractor, of course, had a master services agreement. And in that MSA, there was a choice of law clause and a forum selection clause, which you see here on the screen. And underlined is the forum selection clause. So the choice of law clause is pretty clear. The parties agree that this agreement shall be governed by the laws of Puerto Rico. And so the parties really didn't dispute that. But what was really at issue is the forum selection. So the forum selection clause, and forgive me for reading to you, but I need it for myself. So the validity, construction, interpretation, and performance of this agreement, meaning the MSA, and all transactions under it shall be governed by courts of the Commonwealth of Puerto Rico. And James Turner Construction argues this is our forum selection clause, and this says that the courts of the Commonwealth of Puerto Rico have jurisdiction over this only. So Turner moved to dismiss the case entirely based on this forum selection clause. And plaintiffs argued, and the trial court actually agreed, that this is not a mandatory forum selection clause. This is something that I think is really interesting, especially about forum selection clauses. So we've got here the word shall. I mean, we learned in Law School 101 that the word shall is mandatory, but not really in forum selection clauses. That's not enough. What most jurisprudence says that about forum selection clauses is that the word shall is not enough to make it mandatory. It allows it to be permissive. In other words, either party could file in Puerto Rico, but that's not enough to make it mandatory. Instead, in order to make that forum selection clause mandatory, there also has to be exclusive language, exclusivity language, express exclusivity language. It's hard to say. And this obviously doesn't have that. And so the trial court refused to dismiss, would not uphold this forum selection clause, or at least the interpretation that James Turner had. They filed for mandamus in the Court of Appeals. That was summarily denied. And now they've filed for, they've appealed that to the Supreme Court of Texas. So this is pending, and I don't have an answer for you, but I just want to point out the difficulty of this. The other issue, and Travis is going to touch on this a little bit later, is so one of the core claims in the lawsuit involves financing agreements that sort of arose out of this MSA. And so the other issue is whether this forum selection clause, as it's written, that says all claims arising out of this agreement and all transactions under it, whether that means and includes transactions that are arising out of a related but not the same contract. And so we see that forum selection clause just isn't going to save James W. Turner Construction in all instances. The next example that I wanted to talk about is an arbitration clause, and this is something that has been hugely in flux in the last few years, and that is arbitration as a class. So typically, defendants, just like a civil litigant, just like civil litigation, want to avoid a class action. Often, the claims that are going to be brought against a company are so the damages are so small that there's a huge incentive for defendants to put the kibosh on class claims, because otherwise individuals just don't have the motivation to bring these small individual claims because the damages are so low. And so a lot of companies have included in their contracts a prohibition on class arbitration and class civil lawsuits. So in 2019, the Supreme Court issued its opinion in Lamps Plus, and this is again, we see the courts enforcing the FAA and really broadly enforcing arbitration that in a way that favors defendants, or at least in a way we thought typically favors defendants. In Lamps Plus, the plaintiffs were ordered to arbitrate their claims, but the district court allowed class-wide arbitration. And the Supreme Court disagreed and reversed the Ninth Circuit and held that in order for plaintiffs to be able to arbitrate as a class, the arbitration clause has to explicitly allow for that. It can't be ambiguous. It has to expressly allow arbitration as a class. And that's partially because the FAA has really a presumption for individual arbitration. But then we see this play out in a way that may not always benefit the companies. So, for instance, Harrington v. Waterstone Mortgage Corporation, and this is a case that was filed in 2011. So just everything we thought about arbitrations being faster than litigation, this is proving us wrong, really. In Harrington, this is a Fair Labor Standards Act case, and some former employees brought suit against Waterstone Mortgage. The plaintiffs were ordered to arbitrate and were permitted to arbitrate as a class. The arbitration award was for $10 million, and that involved 175 plaintiffs. Now, after Lamps Plus came out, the defendant company moved to set aside that award and won. So it got rid of the class-wide arbitration award. It thought it got what it wanted. But here what we're seeing is the potential for something even worse to happen. So in 2020, the first of the individual claims came up for an award, and a plaintiff was awarded only $15,000 in actual damages, but $1.1 million in fees and costs. And that's a single plaintiff. And so now we've got Waterstone Mortgage, instead of facing a $10 million arbitration award against 175 plaintiffs, it's potentially looking at 175 individual awards by a lot of different plaintiffs. And what I don't have this on a slide, but I think it's worth noting is that, we talked about costs and we talk about plaintiffs' attorneys getting even more sophisticated, just behind defendant companies as they're modifying their clauses. And one of the biggest reasons why companies love forbidding class litigation or class arbitration is because most plaintiffs' claims in some instances are going to be so low that it's not worth it to them to file arbitration claims or file civil lawsuits. But recently, some plaintiffs' firms, especially some big, savvy, creative firms, have essentially been bankrolling mass, and I say mass, not class, but mass actions against defendants who, instead of having one class action or one class arbitration, are going to be forced to litigate or arbitrate against tens of thousands of individual damages claims for various things. And so we see that these sort of three main common clauses to help shape our litigation are not as perfect as we want them to be. I'll just briefly touch then on some other clauses that are of consideration and maybe are not as common, but are things that companies will want to think about. So first, the freedom to contract. It allows for a lot of things. It allows for defined terms. For instance, we can define in our contract what is reasonable conduct. We've talked about the class arbitration waiver clause, and that I think similar considerations would apply to a class action waiver clause. Pre-suit notice clause. That's a beautiful thing, to require a certain type of notice to be sent to your legal department before a plaintiff files suit, and courts are going to enforce that. contractual limitations period clause. Typically, you can contract around statute of limitations. In employment contracts, in most states, you can go as low as 6 months, and you can require a potential plaintiff to file suit within 6 months of their claim accruing. And for other types of causes of action, usually it's as little as a year. But that's a substantial change from most states' statutes of limitation. The non-joinder and a hold harmless clause. This is Travis's brainchild, and he'll talk a little bit more about this. But I think it's brilliant because we represent a lot of product manufacturers, and for a lot of reasons, we'd rather be in federal court. And plaintiffs are going to do what they can to keep us out of federal court, and one of those ways is by suing a forum defendant. Now, when our clients are national companies, but they're selling through local suppliers or distributors, we are worried that those plaintiffs reasonably are going to bring those distributors or suppliers into suit and therefore prevent diversity jurisdiction. So although it's states are going to hold it unconscionable to hold yourself harmless as to everything, it's a great creative technique to think about holding your distributor harmless, so that you've got a reason to argue misjoinder if plaintiffs bring that distributor into the lawsuit. And then finally, third-party beneficiaries and closely related parties clause. This is something to think about. Again, you're a product manufacturer and you sell a leaf blower, and your consumer loans that leaf blower to their next door neighbor. Do these contractual clauses apply to that next door neighbor if neighbor gets hurt? And so those are things that you're going to want to think about. And so I'm going to now turn it over to Travis, who's going to show you how we see all this in action.
Thanks, Maggie. Hey, y'all. I'm Travis Gunn. And first I want to sort of put together what Courtney and what Maggie were talking about, the why and the what, just to give you all some examples. These are a couple of real-world jury verdicts from past couple years that were particularly egregious, and sort of give you an idea as to what sort of contractual strategies might have helped. So in this first example, there was a weed killer manufacturer whose product allegedly caused cancer in this elderly couple. And so they sued the manufacturer and the forum retailers in Alameda County, California State Court. And at the end of the trial, the jury awarded $2 billion judgment, $2 billion of those dollars in punitive damages. And we're thinking, well, this was a Delaware manufacturer. What sort of strategies would they have had available to them to at least assert if they had a consumer contract with these customers? Well, first, there's the potential for removal to federal court. If you're a manufacturer of a product, and of course other businesses, you can foresee in your chain of distribution the forum defendants that will be sued, your dealers, your retailers. You can have a non-joinder and also a hold harmless clause for the claims that you typically see for those entities. So for example, if you're manufacturing weed killer, you're going to see product liability claims. Those are based off your own conduct, not upon the conduct of your dealers or retailers. And so there's a basis to argue that they should be held, the hold harmless clauses should be held enforceable against those other parties and not necessarily against yourself. But what that does, along with the non-joinder clause, it allows you to argue that there is diversity jurisdiction, that these other parties were fraudulently joined, so you can instantly remove. And then you remove to federal court, and what you're looking at is you're trying to get to your preferred jurisdiction. So you have a federal first forum selection clause. In this case, could have had a Delaware court exclusivity jurisdiction clause, go into federal court if there's federal court jurisdiction, or state court if not. Since we removed to federal court and we're looking to move to federal court and transfer, just move the court to transfer you to Delaware federal court. In addition to those sort of procedural arguments, since this is a Delaware company, it could have had a choice of law clause to apply Delaware law to claims brought against it. In this instance, that would have dismissed plaintiff's strict liability claim based off of the inherently dangerous theory. Apparently, Delaware does not recognize that type of claim. And then also, you can have warranty disclaimer clauses. So in this instance, the plaintiff had a warranty claim, but you can, of course, disclaim warranties. You have to do it expressly and explicitly, but that option is available. So those would have been a couple of strategies that this manufacturer could have considered in having a consumer contract. Now let's look at another example. We have a manufacturer of specialty trucks. It was allegedly defectively designed, and it caused injury during maintenance. The truck driver sued in Illinois state court, and the jury awarded $10 million in comp, $10 million in punitive damages. And what kind of strategies are we thinking about if this manufacturer had a consumer contract? Well, he could have removed the federal court with, once again, the non-joinder and hold harmless clause. There was a forum state retailer, I believe, in that case. So carve them out of the litigation as far as the manufacturer is concerned. And then you can try to transfer to Washington court because the manufacturer was a Delaware corporation with Washington headquarters. So Washington state has a reasonable connection to that contract. And then also you could try to apply the law of Washington with a choice of law clause. And Washington apparently is one of the few states that does not recognize punitive damages. So at least in this instance, this is a potentially $10 million strategy that this manufacturer could have considered. And then third and finally, I don't want to do too many of these, but just a similar sort of situation. The manufacturer of concrete sealer, allegedly defective concrete sealer, it was ignited by the home's water heater pilot light, caused an explosion. The homeowner sued both the manufacturer as well as the forum state dealer in Illinois Cook County. The jury awarded $10.8 million in compensatory damages, of which only $2.8 million were economic damages. So that was an $8 million non-economic damages award, which matters when we look at, well, what kind of strategies could this manufacturer with Ohio headquarters could have maybe employed? Once again, we're looking at that removal to federal court. Part of that is we really want federal courts for a variety of reasons, but in this situation, we always want federal courts to be considering whether we have a valid contract and whether these litigation-related contract terms apply to these claims. Federal courts are going to take these arguments more seriously, and they're less likely inclined to protect their forum plaintiffs. So we're moving to federal court. We're going to try to transfer to Ohio court with a forum selection clause, federal court, and then also applying Ohio law. And here, Ohio law has various caps on non-economic damages and product liability cases. And even in the worst case product liability scenario, I'm not saying it would apply here, but in the worst case, you can only get no more than $500,000 per plaintiff in non-economic damages. So here with $8 million in economic damages, non-economic damages, this was a $7.5 million potential strategy that could have been used. So that's how we envision the idea of consumer contracts assisting businesses in their attempt to get out of unfavorable forums, applying unfavorable law. And now I want to talk about, well, how do we make this happen, right? That's undoubtedly what people are asking themselves. And there are two main questions there. It's, do we have a valid contract between the company and the consumer? And if we do, secondly, does that contract cover the consumer's non-contract claims? Now, there are some secondary questions I'm not going to go over, but this is definitely something you should be thinking about. Do we have the right terms for our client or for our business? And are those terms enforceable on their own? The typical contract defenses will apply to the terms once you say the terms do apply to a consumer's claim, whether that's unconscionability, reasonableness, or whatever. So the foundational question one, do we have a consumer contract? How do we get a consumer contract? This slide is really just to get y'all thinking. Consumer contracts can exist whenever there is a point of contract, which really is a point of contact with consumers, whether that's a point of sale or lease, whether you have an I agree option on your website or your service terms of use, online sales. If you have a company that uses cell phone apps at the point of downloading or using those apps, you have the ability to enter into a contract. Registrations, whether it's loyalty programs, product registrations, website use, and product packaging. And of course, that's just some stuff that we came up with, just thinking generically about companies, but your own company might have other points of contract with consumers. So there's three types of contracts I want to go through. The first one is the easiest one. It's you already have a contract with your consumers, an express contract, in which case, congratulations, your business model already has the contract. You just need to consider whether you need to modify the terms with those customers. The second type of contract that I want to talk about are product contracts. These are frequently referred to as shrink wrap agreements. That's where the contract terms are not provided to the customer at the point of sale necessarily, but they're provided with the product packaging. This started back with, in the 90s, the modern doctrine started with software license agreements that literally you would have a shrink wrap. You would open up the shrink wrap. You'd find terms inside that said, congratulations, by opening up the shrink wrap, you have agreed to these terms. It's changed a little bit and recently, and we'll go through that in the next slide, but it applies beyond license agreements, software license agreements. We saw it with gateway computers. Back when you used to call up Gateway or buy the computer over the phone, they would send you the computer. You'd open it up. You would have terms inside. Those terms were held enforceable. Most recently, a couple years ago, the 11th Circuit had a shingle wrap contract using the play on term of shrink wrap. It was shingles that were being sold for a home. There was, I believe, an arbitration agreement on the plastic wrapper of those shingles that were held enforceable. And so what is a shrink wrap agreement? There are typically three requirements. One, there's notice of the agreement on the product packaging. This can be literally terms inside, but I've also seen cases where it's like a yellow sticker or orange sticker that says, read me, or something along those lines. Then second, you have, you have the full agreement of the terms inside. And third and finally, you prohibit access to the product without agreeing to the terms, which really is just saying expressly, you agree to these terms unless if you return the product within a reasonable amount of time, like 30 days. In which case, the majority of courts say, congratulations, you do have a contract. Now, there are a minority of courts that say under the UCC Battle of Forms, the contract ended, completed at the sale, and the subsequent terms that are delivered is a new offer, and without an express agreement, more so than not returning the product, you don't have a valid contract. But that's just a minority of courts. Now, real quick, online consumer contracts have grown out of the theory of shrink wrap agreements. Courts call them term wrap. We have click wrap, browse wrap, hybrid wrap agreements. The two main ones are click wrap or click through agreements. The second popular one is browse wrap agreements. Click wrap agreements, real quick, everyone that's listening to this has entered into a click wrap agreement. That's when you see a series of terms that are given to you and you click that I agree button. That is, by and large, a binding contract. Courts think that they're widely enforceable because of the manifestation of assent to the terms. Browse wrap agreement is much more difficult to enforce. That is essentially by using a website, you are agreeing to be bound by the terms of use of that website, terms of use that frequently have arbitration clause in it. Those are much more difficult to enforce. You have to prove that either the consumer had actual notice of those websites' terms or constructive knowledge. And let me tell you, reading cases about constructive knowledge of what the reasonable website user would do in terms of do they see the terms of use link? Do they have a reason to click on that link? It gets really in the weeds and difficult to show, especially without expert testimony a lot of times. Stay away from browse wrap agreements. Really, the easy way to have online contracts are click wrap agreements. But because the online consumer contracts are new, there's plenty of creative ways to come up with new and invalid and enforceable contracts with consumers. The key really is the I accept button or a similar manifestation of assent. So that's all well and good. We have a valid consumer contract. But then the big question is, well, do these litigation terms that we like, forum selection clause, contractual limitations period, can we apply those to non-contract claims, like tort claims? And that's really two different questions that courts ask. They don't explicitly say, these are two different questions, but this is really, when you look at all the cases, they're answering one of two questions. The first is, does the contract cover non-contract claims generally, or is it just supposed to cover contracts claims? And the second is much more complicated. Does the contract cover the subject matter of the consumer's tort claim? or whatever the non-contract claim would be. The language you use in your contract will give you the answer to both of those questions. So just real quick, the easy perspective, does the litigation-related contract term, do they cover non-contract claims? You just look at the language. And is the provision broad enough to be construed to cover non-contract claims is the typical question. And the answer is, if you use explicit language, for example, spell out, use the magic language of contract, tort, equity, statute, otherwise, just list out all the claims you want to be covered by your terms, you will have satisfied this answer to yes. The more complicated question is, well, do these terms apply to the subject matter of my consumer's tort claims or non-contract claims? And let me just give you an example real quick. So if you have a sales agreement for pillows, you obviously have terms that relate to the sales of the pillows, but you have a forum selection clause that says all claims, all disputes between the parties, whether based on contract or tort, shall be brought exclusively in the courts of the Commonwealth of Virginia. Now, what happens is if after that purchase, the buyer gets into a car accident with the seller's employee, so the buyer sues the seller for tort claims arising out of the automobile accident, is that tort claim governed by this pillow purchase sales agreement? Courts view this question from the perspective of relatedness. Sometimes, because of the language used in the contract, that's what they explicitly say. This is a question of relatedness. But even outside of that, they are thinking, well, is this lawsuit really related to this contract? Once again, the answer comes down to the language used. And there are three different categories of language. This is not any court saying this. This is just us. There's general, there's specific, and there's in-between language. And I'll quickly go through each because I know we're reaching the end of our time. Just as a head note, though, it's a good practice to draw at least from the specific and the in-between language. You want to be able to say the same thing in multiple ways so that when a court looks at your contract, you have multiple avenues to get to the same answer that you want. Because you will be dealing sometimes with difficult courts, sometimes with creative plaintiffs' attorneys, so you want to have many roads to get to yes. All right, so let's look at an example of general language. So for example the example that I gave was all disputes, right, between the parties. Courts don't like to read that literally. Most recently out of the Georgia Supreme Court, there was an apartment lease that a contractual limitations period applied to any legal action against the lessor. And the Georgia Supreme Court said, that's nice. We're not going to read that literally because that's a little absurd. Surely you don't mean for this provision in a lease agreement to apply to automobile accidents, shareholder liability suits, or even if one person punched the other, a physical alteration. Is that tort suit really governed by this contractual limitations period? We don't think so. There was an Eighth Circuit case a while back that had the option of deciding on ambiguous language that could be read to mean literally any legal dispute or just disputes relating to the contract. And they opted for just disputes relating to the contract. So if you use this general language in a vacuum, courts are not going to read that as broadly or as literally as you might want. So your answer there is, well, let's use specific language. And I am right there with you. I think specific language is excellent. If you define the scope of the litigation-related contract terms that identify the particular subject matter, then you are in good grounds to argue that the litigation-related terms apply to the consumer's non-contract lawsuit. Let me give you an example. So in this employment contract, there was a limitations period, and instead of just saying this limitations period extends to all claims relating to this contract, which is not unreasonable, but what this company decided to do was any claim or lawsuit relating to my service with the employer. And that was a very specific, targeted area of subject matter that the company knew was a potential area for lawsuits. And in fact, in this case, which was alleging civil rights violations, discrimination, state common law tort claims, there was no dispute that those claims fell within the scope of this litigation term. Now, there were, other defenses that I mentioned, The typical contract offenses about unconscionability and reasonableness, all those were actually rejected. But there is no dispute that the provision applied to this subject matter of the claim. Now, the danger here is thinking too narrowly and excluding potential subjects. Unfortunately, in this case I have cited, there was a litigation-related provision that applied to claims arising from the transportation of any package, which is great when you have litigation about the transportation of packages. But in that instance, it was a complaint about the mishandling of private customer information. So what this means to me, it means be careful about what specific subjects you're identifying, and don't be shy about adding more subjects that you think are at least somehow related to your contract that you can specifically identify as falling within the scope of coverage of your litigation-related terms. But that's not the only thing you should do, because, again, you don't have to just choose any one of these avenues. You should also consider using the in-between language, which seems like a happy middle ground, but unfortunately can be subject to many different interpretations. So there are essentially three common, or the three most common in-between language that you see is, first, arising from the agreement. All claims arising from the agreement are subject to this forum selection clause. Well, what does arising from mean? Well, the Texas Supreme Court about 4 years ago said, well, there's at least 4 different ways that courts interpret that language, and they can be fairly narrow. Like, I think there's some federal courts that say arising from means literally, do you have a breach of contract claim? And in that instance, the Texas Supreme Court, I think, said it was a but-for clause. So, but for the agreement, would you have the consumer litigation? If so, then the consumer litigation is subject to that term. Arising from is therefore, because it is subject to so many different interpretations, I would recommend steering away from just that phrase. Another popular phrase is relating to the agreement. And the Ninth Circuit explained that this includes disputes that either reference the agreement or have a logical or causal connection to the agreement. And that sounds much broader than arising from. You can argue that a whole bunch of things can relate to, they have a logical or causal connection to your agreement. But I think actually one of the most broad way to have an in-between language is concerning or relating to the subject matter of the agreement. And that way you are tying the scope of your agreement not to the actual contractual relationship that's formed, but to the underlying subject matter of that agreement. So you can see where, for example, let's go back to the pillows purchase agreement. You could have a in-between clause that says our forum selection clause applies to all matters, all disputes, tort and contract, that apply to the subject matter of this agreement, and then add in specific examples. So whether the dispute relates to the purchase, to the use, to the borrowing, to the disposal of the pillow, as many different viable or potential areas of litigation you can add in. You're not limited to just one type of strategy. So those are the considerations about how to create a contract with your consumers, and then how to make sure that those favorable litigation terms can be applied, or at least a basis to argue that they apply to your consumers' non-contract claims. And those terms, again, don't need to be, as Maggie mentioned, they don't need to be specifically limited to arbitration or forum selection clauses. Those are very useful, of course, but there are a variety of other additional provisions that can be useful in avoiding the unfavorable jurisdictions applying unfavorable law. So those are the takeaways. I believe we've reached the end of our time. We would love to have some questions. If you submit them to us, we'll definitely follow up. I think we've reached the end of our time, gone over probably. Really appreciate your time today. It was a joy talking to y'all, and look forward to hearing from y'all. Thank you from all of us.